In the beginning of 2020, Assembly Bill 1482 was introduced to California's new rent control law, bringing limitations and restrictions. So what does this mean to you as a landlord or apartment owner? The moment the new bill was introduced to the law, we had so many questions from landlords and apartment owners. How much can I raise my rent? And what are the limitations that I have on the rents that I want to raise? And what are the proper notices that you have to give to your tenants? So we asked real estate attorney Bruce Menke to give us a detailed explanations of what these limitations mean to you. With over 30 years of experience in real estate law and helping landlords navigate through the real estate landscape, Bruce Menke is one of the most sought-after attorneys, well-respected here in our city of Long Beach. Bruce, thank you so much for being with us today.
Pleasure to be here.
Let's get right into it, Bruce. There's been so many things going on in 2020. You know, we begin 2020, a new decade, a new year, and with it comes a new set of limits to our rent control law.
And if only AB 1482 was all that we had to deal with, and if that wasn't challenging enough, we'd have even more on top of that. But we did start the year off with a couple of amendments to a couple of sections of the Silva Code, all brought on by AB 1482, which breaks down into two general categories: rent caps, which is limitations on the amounts at which rents can be raised, as well as just cause eviction limitations. Correct. Both by way of just cause without fault or with fault, but there has to be a justification for an eviction. It would only apply if the tenant involved has been in the property primarily for more than 12 months, but it could also be up to 24 months as far as a requirement if there had been a shift in roommates involved, in which case it would require one of the original tenants being in the property for that continuous 24-month period. What is still consistent is an April over April time frame related to the CPI, but the base is always 5% plus CPI. Okay. That is currently under attack and on the ballot for November, as far as Prop 10-2, but as of right now, looking at a maximum cap of CPI based upon where the property is located, and there's some open issues on that, which are being cleaned up by pending legislation to reflect what the author intended but did not clearly state in the original bill, and which became the part of the Silva Code. And the original limitations for the Long Beach area were basically 8.2%. That has been adjusted downward though, because the April over April numbers that are most recently available is now 0.7. So it's a 5.7% limitation over a given 12-month period.
To summarize, how much rent can you increase in 12 months? In 12 months, you can increase 5% in rent plus CPI. Now, in Long Beach specifically, CPI right now is 0.7. So in 12 months, you can increase 5.7%. So if you're looking to increase your rent today, you go back 12 months from today, and you can increase it 5.7%.
There was massive confusion as to what rate did apply. The cleanup legislation, which is expected to pass, one of 700 bills remaining to be looked at and acted upon, not all related to real estate, thankfully, is that it is a twice a year limit as far as the number of times that you can increase the rent.
Now, in regards to notices, if you've had a tenant living in your rental for 12 months or more, you got to give a 60-day notice. If you've had a tenant living for 12 months or less than 12 months, you can give them a 30-day notice. A lot of landlords now are figuring out that instead of going to a 12-month lease, they're doing a shorter term lease, such as 10 months, 9 months, 11 months.
A lot of our clients, by the way, recognizing that the just cause limitations kicked in after a one-year period of occupancy, made a conscious decision to set up fixed-term leases for less than a year, at which point, if the tenant fails to vacate at the end of that fixed term, whatever that term might be, take 10, 11 months, whatever, it's an obligation of the tenant to vacate, and it is a much easier eviction case or opportunity, if you need an eviction case, to move forward with the process.
Okay, so it makes it much easier that way.
Yes.
Yeah.
Generally speaking, if you have a tenant, which you're entitled to give them a notice to quit, the tenant's been in place for more than a year, generally speaking, they're entitled to a 60-day notice to quit. Now, however, if you are in escrow for the sale of a property and your buyer is a natural person, and by that, not a corporation, not an LLC, not some other entity, but an individual, a human being that is buying the property, and you have not been in escrow for more than 120 days, you can in fact give a 30-day notice to quit. But as with a lot of notices, it's also important that you make sure that you have the appropriate language in the notice, because this is different than a standard 30-day notice to quit. You do have the opportunity in those narrow set of circumstances, if the property is in escrow, you can give a 30-day notice.
Okay, and if it's in escrow, and again, the purchaser cannot be an entity.
The purchaser has to be a natural person.
Got it.
And it has to be a single-family residence or a condominium, a property whose title is separately alienable, similar to what we were discussing when it comes to dealing with the application of AB 1482.
Okay.
In fact, a critical point that is frequently missed is when there is a change in ownership or management, there is an affirmative obligation on the part of the owner, working through their agent or otherwise, to give a notice of that change. The reason that is significant is if you fail to give that notice of change in ownership or management, and you fail to do so timely, you end up with the potential for a loss at a eviction case for non-payment of rent, because until you serve a proper notice, you are prohibited from either serving or prosecuting, and it is a defense to an eviction case. Another area of importance when it comes to dealing with the 1482 issues is that there is a shift, and it's a trend really, of requiring landlords more and more frequently to actually educate tenants. The whole area of landlord-tenant is growing into and continues to grow and grow as a consumer protection style law. It imposes obligations upon the landlords as those with superior knowledge, supposedly, hopefully, on some of these topics, that they are obligated to educate the tenants. And the way that they're required to do that deals with specific language contained in agreements which are being executed now. Also with the statutory language which is specifically required, including in some cases the size of the type, and there's also issues associated with whether or not the tenant actually has to sign off on it. So it's critically important, more important than ever before, that appropriate forms are being used when it comes to dealing with your tenants.
Our goal here at INTI Realty is to make sure that you stay informed, educated, so you can make the best decisions for yourself. So if you have any more questions about the limitations and restrictions on California's rent control law, give us a call. We'd love to help and answer your questions.